Court calls the case People versus Byron Blair.
National Honor for the People.
Honor, Alexis Plume, appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron Blair.
All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1, retail fraud, and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him, as well as an advice of rights, which should be in the file as well.
You have it. All right. Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Okay.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Byron just compared Judge Valvo to an executioner. This is courtroom humor at its finest. But underneath the laughter, you can feel his nerves. Facing sentencing, even for retail fraud, can be terrifying when you don't know the judge's reputation. Imagine walking in, unsure if you're getting leniency or the hammer.
Yeah. You scared me. Like, who is Valvo? Like? I'm sorry. You like, are you sure?
Like, who is Valvo?
Talked about the
Oh, she's the
judge
chief
in
judge of the
15th
15th District Court.
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh,
You're gonna be
I
sentenced
got you.
down
I
to
got you.
Okay, what do you got me for? What are you telling me?
No, I understand what you were saying. Like, the way you said it was like I was just imagining an executioner or something. Oh, like I was scared for a minute. Like, who is Valvo?
Oh, so you
Like,
thought Judge Valvo was an executioner?
Yeah, like you know, it's not gonna be me.
No, I'll call her today and let her know.
No.
I mean, I just to share that information.
No, sir. I'm sorry. Okay, I'm sorry.
Wow, and of all the judges, say that. All right. Okay, you're clear now. I'm just taking your plea. You would have a right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
you. You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to
yes,
the charge?
Yes,
you do?
Yes,
all right.
yes,
and to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
There it is, the guilty plea. And just like that, Byron gives up his right to a trial, to confront witnesses, even to appeal. Quick reminder, in criminal law, guilty pleas resolve over 90% of cases in the U.S. courts rarely see full trials anymore. Plea bargaining is the real engine of justice.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off. You're not under the jurisdiction of any court at this time.
I'm on probation. No,
he's on probation.
I just took probation. I'm trying to get all of my stuff together. I've been on.
I don't know what that meant. Counsel?
He was not on probation or parole at the time of the offense. He has now recently been sentenced to probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, I am.
of your own free will. And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washington County, State of Michigan. Tell this court what you did on that date involving the M-Den store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that the store had for sale.
Yes.
They were open to the public.
Yes.
And you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
Sir.
All right. And you didn't have anybody's permission to do that?
No, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo.
Circle the calendar, May 20th, 2025. That's when Byron finds out his fate. And notice, the judge doesn't sentence him today. That job goes to Judge Valvo. The plea judge makes sure the process is solid. No coercion, no misunderstandings, then hands it off. It's like passing the ball in a very high-stakes game.
Not execution.
I know.
All right.
And Your Honor,
I'm going to call her, though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there, as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th, he would
please,
get a.
Please go on.
I'm sorry. I do believe his other cases in 15th would revert to personal bonds if he was given a personal bond on this case.
Any response?
Your Honor, this is one of 5 pending cases holding the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm going to request that bond continue at least until the time of the PSIR.
I tried, but I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital, you were going back and
called
forth
up here.
between Wayne County and here.
I called your office up here, and I was known that it was a mistake because y'all had me down as being in custody doing
Y'all, that's me.
Not y'all. Okay.
Go ahead. No, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah. The big
Okay,
y'all.
yeah. Okay, go ahead.
Okay. It was a mix. Okay. One incident. I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
This is the messy side of the justice system. Overlapping courts, different counties, probation, tether malfunctions. It's a bureaucratic pinball machine. And who gets crushed in the middle? The defendant. Whether or not you think Byron's excuses are real, this testimony highlights how easily someone can get trapped bouncing between jurisdictions.
Ruby, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping-ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never Zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washtenaw County. For what? For not going to court. I said, okay. I come out here to Washtenaw County. I ended up in custody trying to figure out how to turn myself in. I come back up in here. Y'all set me another court date. Now guess what happened?
That's it. Big y'all.
The Washtenaw County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washtenaw County for missing court. I'm like, I'm ping-ponging back and forth. When I just got my tether off on the 11th, they called y'all Washtenaw County.
Y'all, all of us?
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advise and release, take care of it when you get up here. So I got up here. I got with my caseworker, this, that. I was supposed to be going to this transitional housing stuff set up, this and that. I made sure I had my housing stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That could be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in. But if you're asking me to reduce this bond, right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than
job
me.
for the last hour.
Huge win for Byron. The judge just knocked Bond down to a personal recognizance, meaning he can walk free without posting cash. This shows the court was swayed by his story, health issues, and lawyer's advocacy. From potential jail time to sleeping in his own bed, that's a game-changing shift in one ruling.
Yes, Your Honor.
That's what?
Yes, there were other holds, and I said yes.
And
4 other cases that have.
4 other cases, that's what you were saying
Yeah.
before we.
And I'll just put the court's information too. I see a 2019 case, 2022 case, 2023 case, and a 2024 case.
Grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
Thank you.
You're welcome.
Thank
Take care.
you. You too, sir.
And I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right, big eye.
Court calls the case People versus Deshaun Clifton.
Your Honor. Assistant Public Defender Dr. Leave on behalf of Mr. Clifton. And Your Honor, today we're going to be requesting an adjournment. Mr. Clifton, can you state your name?
Deshaun Clifton.
Thank you.
And Your Honor, today we're going to be requesting an adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Excellent. Probable cause conference will be adjourned May 15th, 2025, 9 a.m. Bond continued.
Your Honor.
Thank you. Case People versus Zachary Bruno.
Richard McDuffie for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
We will try our best.
Preliminary examination in person, May 6, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
All right, thank you.
Oh, that I passed it? I thought he was on his way. Court does call the case, People versus Antonio Cornelius.
And good morning, Deb Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay.
For all to
Discovery is complete.
To our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6, 2025. 9 a.m. Sorry. 12 p.m. 12 noon before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Gregory Davis.
Richard McDuffie for the people.
And that is me again. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you state your name for the court?
Gregory Davis.
Thank you.
Your Honor, this has been postponed a couple times. And we were trying to see if we could consolidate it with the case that we were told is upcoming. That case has not been charged or authorized. So we are asking for an exam date at this time. In terms of discovery, I did request the 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Ms. Yagi, I thought we sent that 911 call to you 2 weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6, 2025. 9 a.m. before Judge Perry.
Your Honor, may I briefly just address bond?
Briefly.
Okay, this is one of 2 cases that are holding him, or he has 1 or 2 cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. And somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a 5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our third PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud. He was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
Response from the people?
Your Honor, I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available, an officer that was going to be gone for quite some time. When one of Mr. Davis's cases was pending, we had a new incident where he showed up to that victim whose his mother's house and was trying to get in. Essentially, we have NDOB on that case. We have some bond concerns, obviously, there. The domestic violence case, I don't believe it's related to some of these other incidents. The new warrant, I've heard, we do not have a response back on that further yet. But that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that may be because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics, I think, at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, let's see, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing order on this file. We'll be requesting that, obviously, in his history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm going to grant your request.
Thank you.
Another big legal moment. The judge grants a 10% bond provision. Translation: instead of paying the full $5,000, Davis can walk with just $500 down. This isn't just about money. It's about access to freedom. Because let's be real, for many defendants, the difference between sitting in jail and getting out comes down to a few $100s.
Bond will be set at 5,000. I'll give a 10% privilege on that. Thank you.
Thank you.
Are there any no contact orders on this matter? I'm not sure what Ms. Jackson was referring to. We got a contact order with it at the time. So
That is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was supposed to.
Is that Ms. Freeman?
It is Martha Freeman, yeah.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case.
Okay.
Thank you.
thank you for your concern.
Thank you. Okay, super.
Thanks. Court calls the case, People versus London Dottery.
Pretty good.
Oh, boy.
Court shall cease the first assistant public defender on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did
She
you?
graciously forgave.
Did she accept your apology?
She said she did. I
She
pray
said
she
she
did.
did?
Yeah, she said she did.
Okay,
So I hope she really did. She said she did.
okay.
Thank you. State your name, sir.
London battery.
Thank you, Judge. I have submitted the green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
Whichever one is better for the court.
No. I see how you snuck.
Not picking my date. Just
I know. I saw how you did that. May 20th,
thank you, Judge.
2025. 9 a.m. bond will continue.
All right.
Oh, May 20th is 22nd.
The 22nd.
Yes.
Thank you, Judge.
Thank you, Miss. Court calls the case of the people versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. Okay, what are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. Oh, it's 24th. I have explained to him he has an absolute right to that exam. I believe the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination? Gerard, you're waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your
Okay.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we'd waive reading, stand mute, ask the court to enter a not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for May 5th, 2025, 1:30, Judge Hammoud.
Your Honor, I believe he has other matters set with Judge Hammoud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine. Judge.
Okay, good. Thank you. Bond continued. I cannot figure everything out. Court does call the case, people versus Gervais Drake.
And then we have people.
Assistant Public Defender Jay Valentine on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 6th.
We'll do our best, Your Honor.
Preliminary examination in person, May 6, 2025, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case, people versus Haley Gregg.
Jennifer Douglas for the people.
Oh, she was still here.
I'm back. Couldn't get rid of me that easy. Christina Costantino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
Is this the only thing holding her?
No, Your Honor.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th.
Fortunately, Judge, I'm in trial next Thursday, so I can't do next.
Can't do the 1st, so I'll set it for the 6th for BCC. It's a Tuesday.
I haven't looked at the 2,000 cash or surety bond on an RNO A and B case.
That's what he said, no, there's no.
After failure to
That's what I'm
appear.
saying, I don't understand.
All right, I'm just trying to get her, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the first, I'll do the sixth.
That would be great, Judge. Thank you.
May sixth, 2025. That's at 9 a.m. All right, for a probable cause. All right,
Thank you, Judge. I
thank you.
would also like to address bond. I know we've
Yes, you would.
touched on it a bit. It's my understanding her bond in this matter is 5,000 with a 10% bond. It's my understanding of the circuit court matter that I think that people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay. Now go ahead. It's like,
She does.
like she has a job at a liquor store. Go ahead. No, I'm kidding. Go ahead.
Very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would
You're
be.
vouching for that.
She would be.
Yeah, Tina?
She would be. She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We'd ask the court to consider a personal bond. If the court is unwilling to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Ah, cannabis store. No, I'm kidding. Go ahead. Never mind.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of offense in this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to drive, because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, did she? It was a police car.
No, what?
Okay, never mind. My bad.
No.
She just took a car because she had to go. Allegedly.
Allegedly, Judge.
And she's already had a failure to appear on the RNO case back in February. So we don't think that a reduction in bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether to keep her in inpatient treatment at that place?
Well, I'm not really.
I don't know that she's going to need a tether. I mean, if she goes into treatment, no, I'm not going to do a tether on her. I'll just indicate that she can be released from treatment on a PR.
Thank you, Judge.
At this point, however, her bond